Good morning, everyone. Thank you for joining me. My name is Maria Madrid. I am the Director of Latino Services with the Colorado Gerontological Society. We will be starting this webinar in a minute or so to wait for other people to join us. So please hang on with me for the next minute or so and we will get started. All right. Well, thank you once again, everybody that is joining me today. I am very happy to um, begin this advanced care planning webinar series with you. Again, my name is Maria Madrid with the Colorado Gerontological Society. This webinar is part of a webinar series that we will have through the rest of January, February, and it will end in March. So I hope that you're able to join me as the months go by so you become more informed about advanced directives in Colorado. So let's go ahead and get started. Please feel free to send me any information, questions through the QA or through the chat. So let's go ahead and get started. So my objectives for you today is for you to leave this webinar understanding what is advanced care planning, what advanced directives are available, how your personal circumstances determine the forms you use, and what information is needed and what are the best practices when you're completing the advanced directive forms. At this point in time, I am going to turn off my camera so you're able to see the full screen. And I will come back for our question and answer session, turning on my camera. All right, so let's go into what is advanced care planning. So advanced care planning for us at the society doesn't start and stop with medical. It is very much so in planning that takes place in all aspects of your life, medical, financial, and legal. I will go over these three areas with you today, so you understand what that looks like and what we mean when we talk about medical, financial, and legal. So before we begin, this is part of a webinar series. Every webinar is set up to increase your knowledge and help you with a specific area. The information that I will be providing you today is Colorado specific. Every state has its own rules and regulations about advanced directives and what is needed for them to be completed correctly. So all the information will be Colorado specific. Please note that the Colorado Gerontological Society provides assistance to complete your advanced directives. This is at no cost to you. You can find all the advanced directives that we're discussing today at senioranswers.org. And when we talk about advanced care planning, we're talking about everyone over 18 and over. Why 18 and over? As soon as we turn 18, we become adults, and advanced care planning applies to us. So it's an issue that is impacting adults of all ages. So before we get into the particular advanced directive forms, I want to talk a little bit about COVID-19. I know there's a lot of COVID-19 fatigue, but I thought it was important to talk about advanced directives before and right now and what will happen after COVID-19. So, COVID-19 has impacted all areas of our lives, how services and supports are delivered, and how we're accessing those services and supports. The impact and demand to the medical system has brought about crisis standards of care. This is how the medical community will allocate services when resources are limited, in the event that the needs exceed the available resources. Um, so we're talking about really if we come to a point where there's a higher need than resources available, how would the medical community then say who gets a ICU bed or a ventilator? Day-to-day access to medical services are now accessed differently. So instead of going to your doctor's office, now we're doing telehealth. Also, a huge area that has been amplified is disparities. Disparities within racial, ethnic communities, communities that English is not their first language, or are monolingual in another language. There's well documented disparities, and the pandemic has just amplified and really has brought um, light to the disparities, that those disparities could no longer be ignored, and they have really come to the forefront. Every part of our life as we know it has been impacted. Um, there's so much that we still don't know, everything from um, short term, long term impacts of COVID-19 survivors, if they're going to need long term care, if there's a disability resulting from this. So, all of these things impact how we receive medical services. And the pandemic has also, in addition to everything that is our medical services that we need and how they're delivered, everything from the political, economic, and social has been impacted too. So this is a huge impact, and a lot of folks hopefully will remember 9/11. So with 9/11, and the reason why I bring 9/11, because if you look back at how we traveled before 9/11 took place, and after 9/11, this is what is happening with advanced care planning. There's a way that we did advanced care planning before COVID-19, and as things are progressing, the way that we see advanced care planning is changing. So, when we talk about a new normal, it's going to impact every area of our lives, including advanced care planning. So, advanced care planning, the conversation around it has become a from a nice to have to a must have. Why? Because we have changed how we communicate, how we receive services. We've moved from a person to person model. You went to a specific location and you received a service. Now we've gone to this virtual communication world, which we're doing exactly right now. Everything from medical, which is telehealth, to what we're doing today, an educational webinar, meetings, virtual appointments, virtual connection with our family members, and so much more. The reason why I bring this up, this virtual communication world, is because we are receiving medical services and follow up through this virtual connection. And if you don't have access to internet, to a device that is able to connect to the internet, and if you don't know how to make all those things work, then you're falling into an area where you're not going to have access. So, really, the key as we move forward in this new normal, in this virtual communication world, the access to stay up to date and to have access to things is really to address that digital divide. This digital divide comes in many forms. Either where we live, there's lack of internet access. A lot of our rural areas in Colorado see this. Some individuals might have internet, but it's pretty spotty, so they're not able to fully get into a platform like Zoom or something else that requires a lot of power to it, so they're not able to. Or there's individuals that just don't have the knowledge that is required to maneuver how to access Wi-Fi, how to have an email address, and how to get onto telehealth or educational webinars. So as we go into a nice to have to a must have in advanced care planning, this virtual communication world is huge. So let's move on into what advanced directives are available. I will go into the different medical, financial, and legal areas. We're going to begin with the medical. These are the most common advanced directives that some of you have seen. So just some keynotes before we move into medical advanced directives. So in order to complete any medical advanced directive, you need to have decisional capacity. Decisional capacity means that you have the ability to provide informed consent or refusal of medical treatment, or the ability to make informed healthcare benefit decisions. This means that you have your mental capacity and you're able to say yes and no. So an individual that has a cognitive or developmental disability where they're deemed not to have decisional capacity, these documents would not be appropriate for them. It's for someone that is able to give permission, that is able to take the information that is given to them and say, yes, I want this type of medical treatment or not. Advanced directives are different legal documents that allow everyone ages 18 and over to make decisions about future medical needs. So this is whether it's a medical emergency or the person becomes incapacitated and they're not able to communicate their needs. Another key thing to know is that Colorado is not a next of kin state. This means that everyone over the age of 18 and over needs to have advanced directives to allow the person of their choice to speak on their behalf in case they become incapacitated or there's another medical crisis where they're not able to communicate their needs. So let's say that someone's married, their spouse would not be able to automatically come in and make decisions for them. They would need to have it in writing, and that's where the medical advanced directives come into play. So that's what it means that Colorado is not a next of kin state. Once again, we're talking about everyone 18 years of age and older that should have medical advanced directives. So once again, anyone that doesn't have that decisional capacity is not able to complete advanced directives. And that's where we get into the legal area. So what you see now are the most common advanced directives. However, I'm going to go through 8 different ones with you today in the medical arena. So the first one, and I would say one of the most important ones, is the medical durable power of attorney. The medical durable power of attorney appoints who is going to speak on your behalf if you're not able to communicate and you need medical care, whether it's a medical crisis or you had a car accident, which any of us could have at any point in our life, and we're not able to communicate our needs. Someone would be able to communicate for us if we have a medical durable power of attorney. So depending on the form that you use, you could use a standard form like the one that I will make available to you. this form is to fill in the blank and pretty easy to follow. However, if you are able to go to an attorney and get a medical durable power of attorney completed, it might have who could speak on your behalf and then some additional items on there that we traditionally see in the living will, which is another advanced directive. So medical durable power of attorney. This is where you appoint your healthcare agent. The agent is the person that would speak on your behalf if you're not able to communicate. And you're able to also add on there two alternates. So think of it as your agent being your plan A and your alternates being your plan B and C. So let me just give you an example and I will use myself. So in my case, my sibling is my healthcare agent. Prior to COVID-19, we would travel together a couple times during the year. So in the event that he wouldn't be able to speak on my behalf because he was in the same situation, I have dad as alternate number one, and in the event that neither my sibling or my father would be able to speak on my behalf, I have my second alternate, which is mom. Not everybody has three individuals in their life that are able to speak on their behalf. So if you're able to have two additional alternates, that is best case scenario, because if something happens to your agent, then they could go to alternate one. If agent and alternate one are not available, then they could go to alternate number two. Um, so that is one of the things that you could do to further protect yourself in case that something happens to your agent, especially right now during COVID times that any of us can get COVID-19. So most important document, this is who is going to speak on your behalf, who's going to advocate. When you're thinking about the person or persons, they don't have to be blood relatives. The most important it's that it's persons that you trust, persons that are available in case of an emergency, and if you need ongoing care. So when you're thinking about those individuals, before you complete any of these documents, we want to make sure that you first have the conversation with those individuals and know that sometimes the individual that you had your heart set on that would be on this document might say no. And the reason why I say this is because not everybody is in the space to be able to accept such a responsibility. So know that if that is the case, you will need to look for another person or other persons, because the last thing that we want is for you, in the event that there's an emergency, that agent gets called and the agent says, no, I don't want this responsibility. And you're kind of at square one, not having someone to advocate on your behalf. So the next advanced directive is a living will. Although it has the name will on there, we're not talking about property. We're talking about what medical preferences you would want in case of a terminal condition or a persistent vegetative state. So this document, there's two schools of thought when it comes to, is this document needed or not? So the first school of thought says you don't need this document if you have an agent that is assigned in a medical durable power of attorney that knows you well, that knows your preferences, your wishes, and what is going on in your life. The other school of thought um, says, yes, this document is needed because it is a written document that outlines the preferred treatment. And in the event of a medical emergency, sometimes we forget things, and the agent assigned in the medical durable power of attorney now has it in paper what that individual wanted. So this is one of the documents that is a question mark whether you need it or not. The medical durable power of attorney is a must because that way someone can advocate for us. If we talk to our agent and they know what's going on, if we have any health issues, what's going on with our health, if they're available, if they're part of our life ongoing, then that first school of thought would say you don't need it. If you just want to make sure that those things are documented as far as your preferences, whether you would want life-sustaining procedures, if you would want artificial nutrition and hydration, if you have any other medical treatments that you would rather not have, that is the area where you could document those documents. These two documents, the medical durable power of attorney and the living will, they do not require to be notarized, but best practice is to get them notarized. The notary is not an expert on the document itself, but what the notary does is certify that you are the one that signed the document, and that you were doing this without anyone forcing you to complete the document. So it's just another check mark in best practices that the document was completed in front of an unbiased party, and that they're certifying that you indeed signed this either document. So let's move on to the CPR directive and the most. So the CPR directive and the most, those are medical orders. And I lumped them in medical advance directives because they're specifically dealing with medical. So basically what makes the CPR directive and the most two different documents is because they, um, compared to the medical durable power of attorney and the living will, is that when you're completing this document, you need to complete it with your doctor. So the CPR directive is when you are opting out of receiving CPR and you're a healthy individual. So you are saying, in case of any emergency, do not resuscitate me. The medical system is set up to keep us alive. So if there's no CPR directive in place and it's not available during the time of need, when that medical emergency is happening, then they're going to perform CPR. So in order for a medical professional to not administer CPR, you would need to complete this form with your doctor. And this form is for healthy individuals. The most form, which is the medical orders for scope of treatment, this is also a doctor's order, and it's focused on end-of-life care for patients that are chronically or seriously ill. If you are a healthy individual, this is not a form that you should have as part of your medical advance directives. And this is the reason why. A medical form is a order from your doctor to every other medical professional that you will encounter. So if you're a healthy individual, let's say you have something that is very treatable, like a urinary tract infection, and you end up in the ER, in the emergency room, and in your most form you've said that you only want comfort care. This means they're only going to keep you comfortable. um, then that's exactly what that medical personnel is going to do. They will see what's wrong with you, they will keep you comfortable and send you home, instead of fully treating you. And this is where it can become a barrier if you are healthy, because you are not dealing with a chronically and serious illness that you want that consistent level of care every single time you go in. So for individuals that are healthy, they should not have a most form. The scenario that I gave you is a scenario It's a real life scenario that we have seen over and over at the society. A urinary tract infection is a very treatable issue at any age, but because of that most form, which is a doctor's order informing all other medical professionals how they need to treat that patient, um, then that could become a barrier if, like I said, you're healthy. So we want to make sure that only chronically or seriously ill patients are using the most form. Also know that the most form does not assign an agent, so you would need to have a medical durable power of attorney to assign who's going to speak on your behalf. So let me move on onto the next four medical advance directives. So in the event that you have a medical crisis where you can't communicate and you need medical care, um, then this is where the medical healthcare proxy comes into play. The medical healthcare proxy should only be used when a person has not appointed someone to speak on their behalf to be their agent using a medical durable power of attorney. This form specifically will be completed wherever that patient has been admitted. So it could be a hospital, it could be another healthcare institution. That medical team will be responsible for calling everyone in your life. And basically, they make the decision of who becomes your medical proxy decision maker. So note that yes, you will receive treatment. Someone will advocate for you, but you have no say in who that person is. So in order to avoid that scenario, you need to complete a medical durable power of attorney that assigns who's going to speak on your behalf. So if you complete the medical durable power of attorney, you don't need to worry about the medical healthcare proxy. The next medical advance directive is medical aid in dying. So medical aid in dying came out of the Colorado End of Life Options Act that authorizes medical aid in dying to Coloradans that are terminally ill, that they're adults, and that they have a prognosis of 6 months or less of life to live. These individuals must have decisional capacity to make this request. They need to make it verbally in person to their primary care doctor, and they need to be able to administer the medical aid in dying drugs. So there's a whole process and there's forms that need to be completed. This is specifically for terminally ill adults that are Colorado residents that have that prognosis, that they still have decisional capacity and that they're able to make such requests. So if the primary doctor doesn't want to participate in medical aid in dying, under the act, they do have the option, medical staff have the option to opt out. If they do, then at that point, you would have to choose another primary care doctor to work with you. But once again, this is for individuals that are terminally ill, that are adults and have 6 months or less, a prognosis of 6 months or less of life, capable of self-administering the medical aid in dying drugs, and be able to make the 2 verbal requests in person to their primary care doctor. Next is the behavioral health order form. It is also known as the Psychiatric Advance Directive. Similar to the most form, this form is everything that you want, but for your psychiatric mental health care needs. So this document both assigns who you want to speak on your behalf. So for your behavioral health, um, in the event that you're not able to communicate, or you're in crisis, um, who's going to speak for you? You're able to assign alternates. And you're also able to document, what are your diagnoses, what medical medications are you receiving? Would you like to be admitted to a facility? All of those things would be outlined there. And this is specifically dealing with behavioral health needs. So if that is an area where you foresee that you would need support, this is a document that should be a part of the things that you check off that you would need to complete. And once again, before you complete this form, whoever you're considering to be your agent, your alternates, make sure that you have those conversations with those individuals, that they are people that you trust, that they are available in case of an emergency or if you need ongoing care. And this document is also available, and I will provide everyone with our advanced care planning toolkit that you have access to all of these different forms. The last medical advance directive is a hybrid of both um, well, actually, all three of medical, financial, and legal. It's the designated beneficiary agreement. This is a legal document that allows two unmarried adults to put in writing how they're going to support each other and have legal rights, benefits, and protections for each other to be able to speak on each other's behalf for medical treatment, to administer each other's estate, and many other things. So this is a document that does need to be notarized, and it needs to be submitted to the county clerk and recorder. And if any of these two unmarried individuals become married, that document becomes null and void. So the designated beneficiary agreement, remember, it's between two unmarried adults, and it really covers finances, it covers medical, and it covers all the three areas that when we speak about advanced care planning at the society, it covers. So that is another advanced directive that you could have in your pocket if you are unmarried and there's another unmarried person of trust in your life where both of you want to be that support to each other. And you would have the two individuals outlined, and you would be able to say how you want to support each other in that document. Okay, so I've included these decision trees for you. So after you no longer have me speaking in front of you, and you want to look at the slide again, you're able to decide what documents are recommended for your situation. So I'll just go through this one so you could get an idea. So basically, the question is, what advance directive should I complete? So the first question is, do you have a serious life-limiting medical condition? If the answer is yes, then we recommend that you complete the medical durable power of attorney, a living will, and a most form. If your answer to do you have a serious life-limiting medical condition is no, so you're a healthy individual, at this point in time, we're recommending for you to complete the medical durable power of attorney and the living will. And the same scenario goes for the next tool, whether you want to have CPR administered to you. If you're okay with having CPR administered to you, you don't have to take any additional steps. It's when you don't want CPR to be administered to you that now we need to go back to, do you have a serious life-limiting medical condition? If the answer is no, then we're recommending that you complete, along with your doctor, the CPR directive. If you do have a serious life-limiting medical condition, then we're recommending that instead of the CPR directive, you complete the MOST form. The MOST form has the CPR directive included in the form, and it's more comprehensive than the CPR directive. So those are tools that you could use and contemplate more on your situation to determine which forms you need. So here is the scenario in the event that you do not complete a medical durable power of attorney. If you do not complete that document, this is the scenario that would take place. So basically, wherever you are a patient, that medical team where you're admitted will look for your loved ones. They would start reaching out to everyone. The team selects who would speak for you. If the person agrees to that, then now you have a medical healthcare proxy completed. That proxy decision maker is named. But if that person that was selected by the group says, no, I'm not able to do this, I don't want the responsibility, then we would go back to as if the person didn't have natural supports, and now an attending doctor could become that decision maker proxy, but they do have to go through an internal system where an independent determination is made to make sure that the patient lacks decisional capacity, and this is done by an independent physician that is not treating you at that time. And then the physician that it is treating you at the time would need to check in and get consensus from that institution's ethics committee to make sure that they're following the most ethical process. And that's how a physician could become a medical proxy decision maker. So in order to not get into this situation at all, remember, complete your medical durable power of attorney. So I'm going to skip a little bit because now I just want you to think, okay, I've completed my documents, my medical advance directives. What do I do now? Later on, once we talk about all the different advance directives, I'll give you more of a process to follow and some best practices across the line for all of your advanced directives. But let's say that we've completed those advanced directives. Who do you give copies to? First and foremost, you always keep the originals. Make sure you have a folder in a safe place that is accessible to your agent and alternates, but that you have a file where you have all your important documents, including the originals. You make copies and you give copies to your agent, to your alternates, and to your doctor. The most important thing to note is in case of an emergency, those advance directives need to be available in order for your agent to be able to speak on your behalf. If those documents are not available, then it's as if they don't exist. One of the things that I tell folks, if you keep things locked up in a box and nobody knows that that box exists, that there's keys to the box and where those keys are, then it's as if you don't have the documents. So make sure that you do have those documents in a safe place, but that your agent and your alternates know where it's located and that they have a copy. So if something happens, they have access to those documents. The other thing is once you have your documents complete, it's not I complete these documents and I never see them again. No, we want you to review, review, review. Annually, you should review the documents, make sure everything's up to date. That if your agents changed emails or phone numbers or address, that all that information is up to date. If there's a change in condition, um, you might want to review what your preferences are. Do they still meet your needs and your goals and what you want to do? If that's the case, great. If we need to make changes, that is the perfect time. When there's a new diagnosis, this is another wonderful time to review those documents and make sure that they're up to par with what your preferences are. If you get married or get divorced, this is another great time to review those documents, especially if you get divorced. Why? When we assign a spouse as our agent under the medical durable power of attorney, that document becomes void when we divorce that spouse. So if you have your spouse listed and there's a divorce, that document becomes void with that divorce. So you would have to complete a new medical durable power of attorney. Even if you still want them to be your agent, you would still have to complete a brand new one. So know that in the case that there's a divorce, and also at any point that you change your mind about who your agent or alternates are and who you want to speak on your behalf, if you ever change your mind, that's another time that you want to review your documents and you update everything. So those are some best practices to make sure that your advanced directives are up to date and that they reflect your preferences. So let's move on into financial advanced directives. So just like the medical advanced directives, in order to complete any of these documents that I'll be talking about, you need to have decisional capacity. The financial advanced directives are legal documents for individuals 18 and over. Once again, the same thing about next of kin applies to your finances. We're talking about everyone 18 and over, and anyone that doesn't have decisional capacity shouldn't be completing any advanced directives. So with the financial advance directives, today I will cover three different areas or three different directives. The first one is the financial power of attorney. This financial power of attorney appoints who's going to speak for you regarding your financial matters. So this could be financial institutions, this could be property, this could be assistance with your taxes, this could be assistance with helping you apply for civil, military, or government benefits. Um, this document must be notarized. Um, so when you complete a financial power of attorney, make sure to get it notarized. Before you complete this document, once again, have those conversations with those individuals. Some folks have some individuals helping them with medical and a different set of individuals with financial. Some folks have the same person across the line helping them with both medical and financial. We want to make sure that whoever you have as your medical agent, your financial agent, and the alternate, that those individuals are able to work in a team because they're going to have to communicate with each other because there's points where what they're doing will overlap, especially if there's any payment for medical care and supports. Also, your whether it's for medical or financial, that agent needs to be at least 18 years old to be able to assist you with these decisions. The thing about the financial power of attorney, you might have to have more than one. The reason why I say this is because different financial and insurance institutions require their own financial power of attorney. So one of my recommendations is before you begin any of these documents to start taking inventory of your accounts, whether it's medical, financial institutions, insurances, stock, bonds, everything going on with you. Take inventory of those things, and you're going to have to make some calls to see what documents you need to put in place in order for your agent to assist you. So, will this general financial power of attorney suffice, or do you need some additional forms from them and what that process is? So, know that you could have one or multiple financial power of attorneys. I could tell you that major banks, Bank of the West, Chase, Wells Fargo, all of those major banks have their own financial power of attorney form, and they do require for you to use those forms specifically for the accounts that you have with them, and only those forms. They're trying to address a fraud, so they're very specific and they have a process. Some major banks will ask you to complete one for each one of the accounts that you have in their institution, while others have a different process where they will allow for one of their financial power of attorney forms to cover all the accounts that you have. So this is why it's best practice to reach out to those financial institutions, insurance institutions, and make sure that you've followed the process to ensure that the person that is going to help you in the future is able to do so. So the representative payee and the advanced designation, that is specifically for Social Security beneficiaries. If you are receiving any type of benefit from the Social Security Administration, this would apply for you. So the first thing is you have the ability to do advanced designation. So this is where you inform Social Security through Form SSA 4547 that you need, uh, uh, not that you need, excuse me, that you want to let them know that in the event that you need a representative payee in the future, these are the people that you're nominating. A representative payee can only be assigned by the Social Security Administration. And this is when a Social Security beneficiary is no longer able to manage their finances. A family member or friend, 18 years and older, can become the representative payee for that person. But they have to follow an application process. They need to pass a background check. If there's any type of criminal record, that individual will not be able to become the representative payee. The representative payee is responsible for making sure that that Social Security benefit coming to the beneficiary goes to pay for housing, for food, clothing, all of those things. That representative payee needs to document how all the monies are used and submit reports to the Social Security Administration. Um, so when you're a representative payee, that is only for that Social Security benefit. So for everything else, a financial power of attorney would still be needed. So dealing with the banks, dealing with insurance, dealing with all of those things. So advanced designation is to tell Social Security, in the future, if I can't manage my own money, I want a so-and-so to assist me. Social Security puts that document away, and when there becomes an issue of you managing your money, then Social Security is able to reach to that individual, and only then. That document, the advanced designation, can be updated at any point in time. So if you change your mind, that would be when you submit an updated advanced designation to the Social Security Administration. So with these three, the advanced designation and representative payee, those two happen directly with Social Security Administration. The financial power of attorney, there could be one, there could be 20, there could be 5, depending on your situation. And once you take that inventory, that's what is going to determine how many financial power of attorneys you will have. And once again, financial power of attorneys, those do need to be notarized. So just like I did with the medical piece, I gave you a tool to figure out what you need to do. So please do understand that um, these documents are optional, so there's no requirement that you need to complete them, but we really want you to consider because you never know what that'll look like. And one of the things that we recommend that is best practice is do not add someone onto your bank account if they are not your spouse. The reason why we say this is because we want you to have assistance, but for your finances and the person that's going to help you for their finances, never to touch, because then we get into additional issues. When we add someone onto our bank account, that person becomes a co-owner. So we don't want that person to become a co-owner. We want you to be the owner of your account, and we give them the authority to help with that financial power of attorney. That way, their finances, their money doesn't come into play with your money. So best practice, don't add people onto your bank accounts as co-owners, because just here's a very simple example. Let's say that I add my sibling as my as a co-owner to my bank accounts. He has a business. The business goes belly up, and now my sibling needs to file bankruptcy. He will have to report all of his assets, including my bank account, because he's a co-owner. And that's where that's a very real scenario that could happen to anyone. So we want to make sure that, once again, our finances and that person that is going to support us, their finances don't get mixed up with each other, that we have our money, they have their money, and through this legal document that is the financial power of attorney, we are giving them authorization to assist us without our account having to do with their finances. And here's the same tool for Social Security beneficiaries. It tells you if you need a representative payee, if you should have, or if you should do the financial power of attorney and the advanced designation. Also, this leads us to the legal piece. When someone needs help, but they haven't given permission before they need help, then we get into the legal arena. In the legal arena, has two different areas: the legal guardianship and conservatorship. So some states, they have those two as one. Colorado decided to separate them. So legal guardianship is when you have been assigned by the courts, and so is the conservatorship. You have to be assigned by the courts, but the legal guardianship manages the medical. The conservatorship manages the finances and the estate. So if someone needs help and they didn't give permission beforehand, then we're looking at conservatorship. If the individual is able to give permission, then we're looking at financial power of attorneys, financial designation, and representative payees. So let's look into legal planning and considerations. So far we've talked about the medical sphere, the financial sphere. The legal planning and considerations is when someone reaches a point where they need support, but they lack decisional capacity, are permanently incapacitated. That is where we want to make sure we talk about legal guardianship, conservatorship, and then there's other legal tools and end of life care that people should talk about in legal arrangements such as a last will and testament, pre-need funeral, burial, cremation arrangements. So with the legal piece, I've already touched on this a little bit. If we don't have the decisional capacity and we need help with medical, that would be legal guardianship. With money, that's conservatorship. And basically in Colorado, when an individual is deemed incapacitated, only the courts are able to appoint someone as a legal guardian. At that point, the person that is seeking to become the legal guardian or the conservatorship or the conservator, they need to go through the probate court and they need to be at least 20 years old, submit the application, pay the different fees associated to then go in front of a judge and have a hearing. So this process, we will go more in depth in future webinars. So please join us, but know that this is another recourse when we haven't done our advanced directives or when we reach a point where we're deemed incapacitated. And here is another decision tree to determine if legal guardianship is right for your situation. I have included the definition of what incapacitated means in Colorado, so then you could walk through this decision tree. Other legal arrangements to consider is a last will and testament. That document outlines who is going to help through this whole process after we pass away, what is going to happen to our property. So we want to make sure that we understand that only taking care of the medical or the legal, that's not enough. We need to have another type of protection after we pass away, because so far everything that I've talked to you about is good when we're alive. When we pass away, there's a whole nother system, a whole nother set of rules and regulations. And now we're dealing with what happens to your property, who's going to take care of closing accounts and all of those things. So a last will and testament is a legal document that allows for that to happen. Colorado is one of the few states that allows for a last will and testament to be written by hand. I don't recommend that if you have quite a bit of property, especially if you have property in Colorado and other states. I would advise you to seek legal counsel. And we will talk more in depth about last will and testament in a future webinar, so please join me. The other area that I want to bring up to your attention is pre-need funeral, burial, and cremation arrangements. Those are arrangements to consider because there's a financial benefit in doing this before the time of need. Those are insurance policies that you could pay in a lump sum or with monthly installments. And this basically gets you covered. So when you do pass away, whoever is part of your support team will be able to call that policy holder and say, my loved one has passed away, and then they would come and follow all the arrangements instead of trying to figure out what do you want after you have passed away, how that will be paid, and what that looks like. So here is basically the outline of where to go next. So before completing any forms, take inventory of medical, financial, retirement, insurance, your bills, funeral, cremation arrangements, identify what forms make sense for your situation, check with those financial, retirement, insurance, institutions to see what they require for the person that you want to assign to assist you. Before you complete any of the forms, make sure you have conversations. I know people say have the conversation. I say have the conversations because it's an ongoing process. Make sure that you talk to those individuals that you're considering, that it is a person or persons that you trust, that these persons are available in case of an emergency or if you need long-term and ongoing support. And does this person know what's going on in your life? If this person doesn't know what's going on in your life, it's going to be pretty hard for them to say, oh, yes, you just changed medications and this medication is new and she's been taking this other medication for quite a while for blood pressure or whatever have you, right? So once you've talked to those individuals and they say yes, then there's some information that you're going to need. And you're going to need, for the agent and the alternates, you're going to need their full name, their telephone number or numbers, if they have an email, and their full address, because those power of attorneys, whether it's the financial or medical, is going to ask you for that information. And when you are ready to complete forms, know that some must be notarized. The financial power of attorney, the last will and testament, those must be notarized for them to be legally binding in Colorado. The medical durable power of attorney and the living will don't have to be notarized, but I highly recommend that you do. And once again, make sure that you save those original copies and then provide copies to your agent and alternates. And those medical advance directives, a copy should also go to your doctor. So I see that I have gone a minute past our time and we do have some questions. So just note that as part of my follow-up to you, I will provide the resources that you see in front of you. And if you wish to stay with me a little bit longer, I will go through the different questions that have come up, so that way they are answered. So let's see. Here I have questions. So when my husband was placed in a rehab center, they would not accept these directives. They demanded a court order. So one of my questions would be, what was his mental capacity? Because once again, if he did not have decisional capacity, that could have been one of the issues, especially with dementia. That is a very gray area. So unfortunately, without more details, I can't answer. I can't answer that question completely, because Colorado isn't a next of kin state. If someone has no advance directives, who makes decisions on their behalf? So remember the proxy decision maker piece that we spoke about. That person will continue to receive medical care where they're admitted, and the medical team in that institution will try to find family, friends to make that decision. and within that group try to make a decision who's going to speak for that person. And if there's no such person, then the attending physician needs to go internally to determine if that physician becomes the proxy decisional maker. Okay, let's see. In case of an emergency, will a hospital or doctor accept a copy from the agent, or will they require the original? So this is a wonderful question. So one of the things that I recommend is always have a copy, because at that point they know who to call, and if they do need to see the original for whatever reason, the agent or the alternates know where this document is. Just know that if you give an original document to doctors, they might make it into your medical record, and at that point it becomes very difficult to get it back. So before you give an original, I always recommend that you give a copy. And if the copy is notarized, that's additional assistance with ensuring that the document has been verified by an unbiased party. Also, note that other states require medical durable power of attorneys to be notarized, and this is one of the reasons why it's best practice to just get it notarized. Colorado, as long as you sign and date, the medical durable power of attorney is legally binding. So just know that if you're going to travel, to get your medical durable power of attorney notarized so there's no issues. But the emergency room should accept that copy. And if they don't accept the copy, just make sure that your agent and alternates know where to find the original. Let me see. Is there a site where I can download the presentation visuals? Yes. So after this webinar, I am going to follow up with everyone in attendance, and I will provide you access to this PowerPoint that will have links to everything. And I will also give you access to this webinar, which is recorded. I will also upload the webinar to our YouTube channel, so you could see it as many times as you need. Also, my information is in front of you. Feel free to email me or call us at the office, and we're more than happy to assist you through this process as you're trying to figure out what is the best route for you. Next question, will the recording be sent out with the slides? Yes, it will. I will make sure that everyone has access to those. Okay. So this is a note about the font size for the visuals. I believe the individual was not using a full screen, so unfortunately, it was a little bit harder for them to see that. My apologies. Once you get the recording and the PowerPoint, you should be able to see and enlarge the PowerPoint. I thought you were going to cover COVID-19 issues. Are there specific directives related to COVID-19? No, there's no specific COVID-19 advanced directive. This is why having the advanced directives that are already into rules and regulations is key. And those are the ones that we spoke of today. So that's your medical durable power of attorney, your living will. If you do not want CPR, the CPR directive. If you have a chronic serious illness, the most form. And for any psychiatric mental health, having the Psychiatric Advance Directive. All right, let's see. Okay, so let me go on to the chat and check out the chat for any questions. Okay, I recently moved to Colorado. Do I have to redo these legal documents? So every state has its own rules and regulations. I would recommend that you do complete the Colorado forms if this is a permanent move for you. Just because we want to make sure that your documents do get respected, especially with everything going on with COVID. Let's see. Thank you, everyone, giving me kudos. You are awesome. And that concludes today's presentation. Everyone, thank you so much. I look forward to sharing all things advanced care planning with you in the upcoming webinars. You could join me at all the upcoming webinars or the ones that are interest to you. If you have any other questions, don't be a stranger. Feel free to email me. I'm more than happy to answer your questions. If you need further assistance to understand your situation or what that looks like, please don't hesitate to reach out. We're more than happy to do that. As I said, part of that resource slide will include access to our Advanced Directives Toolkit that has all of the forms that we spoke of today, and throughout the different webinar series, we will do some step-by-step tutorials so you're able to complete your medical durable power of attorney, your living will. We'll go more in depth into advanced directives versus doctor's orders. We will talk about legal guardianship and conservatorship, and we'll talk about last will and testament. So thank you so much, everyone. I hope this was of assistance to you. I will see you in the future webinars. And if you need assistance, you have our information. Thank you so much and have a wonderful day.